Okay, today's hearing once again brought the Epstein files back into sharp focus. Senator Jeff Merkley said clearly that when it comes to the Epstein files, the Department of Justice did exactly what the law prohibited. More than 3 million pages were withheld, entire documents were blacked out, and most seriously, despite the law, the identities of victims were not properly protected. Merkley asked, if the Senate unanimously ordered these files to be released, then who is blocking the enforcement of that decision, and why? His question was direct: is the law applied equally to everyone, or are powerful names still being shielded? This is the moment where this issue stops being only about Epstein and becomes a test of accountability and justice. Now, first, let's watch the hearing clip, and after that, we'll break it down.
I compliment the minority leader for coming forth and saying what the Senate has agreed to do, which is to force the Epstein files to be released, must be backed up by the force of law. Because we know that the administration failed to release half of the paperwork, some 3 million pages. We know that they blocked out whole pages in order to disguise, apparently, the protection of powerful men that they don't want drawn into this discussion. And then they proceeded to not redact the names of victims, as the law required. Let us not forget what this entire Epstein scandal is about. It's about powerful, wealthy men grooming, abusing, and raping young women and men. That's what it's about. I cannot understand for the life of me why the Republican leadership just objected for us to seek enforcement of the law that we passed unanimously here. Why is the Republican leadership protecting powerful men? Why are they protecting the administration, allowing 3 million pages to be held onto? Why are they allowing page after page after page to be blacked out to protect those powerful men? Why will they not respond to the fact that when these files were released, they did exactly the opposite of the law and failed to redact information about victims, re-victimizing so many? This is 1,000% unacceptable, and it's unacceptable to our values as a nation. Our values which talk about equal justice under law. That's why, by unanimous consent, we said those files must be released. But it's meaningless if the administration simply chooses not to comply, and then my Republican leadership colleagues proceed to block the ability to enforce what the Senate agreed to pursue: accountability, justice for the victims, transparency over this horrific scandal. Mr. President, I hope my Republican colleagues will reconsider their objection, because what they've just done is wrong, morally wrong, and wrong under the values of equal justice under law, wrong under the values of justice for those who have been victimized, wrong under the value of accountability for the perpetrators.
The hearing clip you just watched focuses on a growing dispute over how the Epstein files have been handled after Congress ordered their release. Senator Jeff Merkley was direct in his remarks and avoided speculation. His focus was on process, legality, and enforcement rather than political rhetoric. Merkley stated that more than 3 million pages connected to the Epstein investigation were withheld. That figure is significant because it suggests the issue is not limited to isolated documents or administrative delay. According to his statement, a substantial portion of the total record was never made public despite congressional direction. He then addressed how the released material was presented. Merkley said entire documents were blacked out, not specific lines or limited sections, but full pages rendered unreadable. His concern was that such broad redactions make oversight impossible. When lawmakers and the public cannot see what information is being withheld, there is no way to evaluate whether the redactions are justified under the law. Merkley argued that this approach directly contradicted what Congress had required. The law called for disclosure with narrow and specific protections. Instead, he said the Department of Justice applied redactions in a way that effectively defeated the purpose of release. In his framing, the department did not simply fall short of expectations. It acted in opposition to the legal standards set by Congress. One of the most serious points in his remarks involved the handling of victims' identities. Federal law requires that victims be protected from further harm. Merkley said that when the files were released, identifying information was not properly safeguarded. From his perspective, this failure amounted to re-victimizing individuals who were already harmed by the crimes connected to Epstein. He emphasized that the Epstein case is not abstract. It centers on allegations that powerful and wealthy individuals abused young people. In that context, protecting victims is not optional. It is a core obligation. Merkley argued that any release process that shields powerful figures while exposing victims represents a fundamental inversion of justice. Merkley then turned to the authority of Congress. He reminded the chamber that the Senate had unanimously agreed that the Epstein files must be released. Unanimous consent is rare and meaningful. It reflects agreement across party lines that an issue rises above routine disagreement. Merkley's argument was that such a decision should carry enforceable weight. He questioned why efforts to enforce that unanimous decision were being blocked. In his view, a law or resolution has little value if there is no mechanism to compel compliance. Without enforcement, congressional authority becomes symbolic rather than real. Merkley posed a series of direct questions. Why were millions of pages withheld? Why were entire documents blacked out? Why was enforcement blocked after unanimous agreement? These questions were presented as matters of logic and accountability rather than partisan accusation. A central theme of his remarks was equal justice under law. This principle holds that legal standards apply regardless of power or status. By invoking it, Merkley framed the handling of the Epstein files as a test of whether that principle still operates when influential individuals may be implicated. He also focused on accountability. Accountability for perpetrators is one part of the equation. Accountability for institutions is the other. Merkley argued that if the Department of Justice can ignore congressional mandates without consequence, then the system designed to balance power between branches fails. Notably, Merkley avoided naming specific individuals or asserting conclusions about guilt. His remarks were grounded in documented actions and omissions. This approach keeps the focus on verifiable process rather than speculation. It also aligns with the idea that transparency is necessary before conclusions can be drawn. For viewers, this distinction matters. Merkley's argument does not rely on belief or assumption. It relies on a sequence of events. Congress ordered release. Large volumes were withheld. Documents were heavily redacted. Victim protections failed. Enforcement was blocked. Each element can be examined independently. The broader implication of his statement concerns institutional trust. When a senator publicly accuses the Department of Justice of violating the law, it raises questions beyond a single case. It prompts scrutiny of whether oversight mechanisms function as intended. Merkley also raised the issue of precedent. If congressional directives can be ignored in a case as prominent as Epstein's, it suggests similar outcomes could occur in less visible matters. That concern extends beyond partisan politics and speaks to the structure of governance itself. He concluded by urging his colleagues to reconsider their objections. He described their actions as wrong, not only legally, but morally. By framing the issue this way, Merkley reinforced his central claim that this is not a technical dispute. It is a question of values and responsibility. For the audience watching, the takeaway is not a final determination about the Epstein files. It is an understanding that the issue remains unresolved. The conflict between legislative authority and executive discretion is ongoing. The questions Merkley raised remain open. Will the withheld pages be released? Will redactions be narrowed to comply with the law? Will enforcement mechanisms be allowed to function? Will victims be protected while accountability is pursued? These unresolved questions explain why the Epstein files continue to return to the Senate floor. The issue is not confined to past events. It concerns how the system responds now and whether stated principles are enforced in practice.